Right, good morning and welcome to Healthcare Law in Ethics. I gave you some materials to look at ahead of our first class. Can you update me exactly what I gave you to look at? Anybody? What did I give you to look at? Can anybody?
You give us some videos and also a document that is written by one company, and it is outlining some health issues that need to be addressed, more especially concerning the law, the legal aspect of it.
Okay, all right. So I hope you're able to look at the materials. You also watch the movie?
Yes, Prof.
Okay, all right. So let's, within the context of the reading I asked you to do, we have a nice breaking brainstorming. So how will you define healthcare law and medical law then, if you read the material I asked you to read? Anybody?
Prof, by my reading, I came to understand that when we are looking at healthcare law, we are looking at the capacity of a person to access the health facility and the obligation which is also imposed on the professional workers or all the workers with respect to the patient coming to the access or to come for their services, what they are supposed to do and what also the patient also do. So basically that is the point that I'm getting from.
Okay. All right. Any other person? How do you do? Okay, so I think it appears only Joshua is the one who did the reading. Okay, so healthcare law or medical law is an aspect of the law which addresses the interaction between law and medicine. So the interaction between law and medicine certainly bigger than or broader than just the doctor-patient relationship, because there are various aspects of that interaction. Yes, doctor-patient relationship is definitely a very important site as far as medical or healthcare law is concerned. But then beyond that, we also have other major issues, such as the challenges which advances in medicine and the various dilemmas, especially ethical dilemmas in the field of applying new learning, new technology to medicine and also to human being. The issues that they bring up. These are all matters which are explored. So for example, we all know about assisted reproduction. And if you know the processes which goes into it, and especially you can do pre-diagnostic genetic implementation, what we call like the designer babies phenomenon, for example. That is, you can literally say that when you are processing the embryo, right, within the cycle of in vitro fertilization, that is the IVF, I want a boy or I want a girl. Or if it's a boy, I want a tall boy with the blue eyes or something like that. or if it's a girl, I want a girl who will develop to have a nice figure and so on and so forth. So you give some of these preferences, and the technology is there. They can actually manipulate the IVF process to help you to get a child or children with your desired features or characteristics. But then, question which arises this: is it proper for human beings to be reduced into that? Does that not amount to commodification of human life? Or is it the case that because knowledge, and for that matter, technology has advanced up to a certain level, we should just allow any possibility to be explored? Or we need to draw boundaries so that we can say that despite the fact that scientific advancement is making this possible, but we think it is not right. It is in conflict with acceptable boundaries of our values. So we don't want scientific knowledge to go into this area of medicine and so on and so forth. So these are some of the matters. And not only that, we also know issues about even trial of new medicine, right? New drugs and so on. Drugs which have never been tested. And we don't know the side effects of those drugs. Should we allow such drug to be tested on human beings when we don't have scientific certainty regarding the potential adverse effects on the user or the patient, as the case may be? And again, when it comes to human beings, our tissue, our organs, and all that, they become defective. And it may be necessary for a patient to get an organ harvested from another human being, or even from an animal like pig, what we call the xenotransplantation. So all these things are there, and they present unique challenges which need to be addressed. And the area of the law which allow these challenges to be addressed is what we call the healthcare law or medical law, or in some places they simply call it like the health law, and so on. And again, when it comes to issues of public health, that is matters of the health affecting the entire population or significant section of the population, we also see a unique interaction between law and medicine there. We all remember the COVID-19 not too long ago, what we saw in the world. And you remember, even in Ghana, we rushing to pass a legislation we call the imposition of restrictions act or something like that, under which certain interventionist measures could actually be deployed by the government in its effort to help safeguard the public health. And issues arise. How far can a person's liberty, autonomy be circumscribed in the interest of safeguarding population of, the health of the entire population or section of the population, as the case may be. So these are some of the things. And as I indicated, in terms of nomenclature, we have differences in some places. They will call this area of the law healthcare law. Other places, they will call it health law. Even some people will just call it the law and medicine, okay? But then let me say that if you come across what we call medical jurisprudence, okay? It's not necessarily the same as healthcare law and ethics or medical law and ethics. That one usually relates to forensic aspects. That is how we make use of medical knowledge and technology in investigating crimes or investigating accidents and so on. So DNA, for example, it is very important if you go to the advanced countries where they have the resources. You cannot have serious criminal trial without DNA and some other biometrics of the accused person or the suspect having been taken and having, and it will have to be made use of during the trial, so that we have if not absolute, we have a significant certainty that yes, the person who is being tried is the one who, according to our scientific data, actually went there or did that, and so on and so forth. So that is, we have another field, as an aspect of it, like evidence or forensic medicine. So that is a medical jurisprudence. We are not really interested in that for this particular model. So we also come to note that, or appreciate that, healthcare law or medical law is also concerned with the mediation of bioethical dilemmas, right, generated by healthcare practice. There are a lot of dilemmas. If you say dilemmas, of course, remember the great Amata Edu, may his soul rest in peace, who wrote The Dilemma of the Ghost. So if nothing at all, following her death, we revisited her book, The Dilemma of the Ghost. We're not talking about that. We're just talking about dilemmas in healthcare practice. Yes. Just a minute. Yeah, so I was just making the point that even when it comes to medical practice, even routine medical practice, we get situations of dilemma. That is situation where you have a more than one course of action open to you. Should you do X or Y, or should you do Z? For example, you have limited treatment available. We have, let's say, about 50 patients, and they all need that treatment, but the treatment is not enough for all the 50. And let's say that it can manage 5 patients. Now, all these 50 patients, they need the limited available treatments in order to live or something like that. Now, how are you going to decide which of the 50 you give, 5, which 5 out of the 50 will you give the limited treatment to? So these are dilemmas. Are you going to take into account the age, their age, and how long they've got to live in this world, or the contribution they're making to society, and so on and so forth? So you need to make a lot of calculations, right, before you can arrive at who should get the treatment or should not get the treatment, and so on and so forth. I mean, this is just one minor example of the ethical scenarios. I mean, the dilemma, scenarios of dilemma which come up in medical practice. Now, being a field of law, we are confronted. Is it part of public law or is it part of private law? I dare say that healthcare law or medical law actually straddles between these two branches of the law. Why is it so? Because there are, of course, we remember private law, tort, contracts, and so on and so forth. And public law, criminal law, constitutional law, and so on. Of course, property and family law, these are all private law matters. They are not public law. They are not public law. However, if you look at healthcare or medical law closely, you will come to appreciate that it is really not very convincing to insist that healthcare law is a private law subject. Neither will it be completely convincing for you to insist that it is a fully public law subject. It's actually straddles, that is, it partakes of private law and then it partakes of public law. For example, you'll be talking about issues of consent and so on and so forth. These are matters which we can see in contract and tort and so on. There are some matters where we come to criminal law, causing unlawful harm and so on. And if you look at even at 29, you notice that when it comes to medical treatment, some exception is created, isn't it? Causing unlawful harm. And again, when it comes to organ transplantation, right, we also confront issues of property law. If, for example, you remove part of everyone, if you've all got the, let's say 2 kidneys and so on, and where the person is completely healthy, he or she can live on only on 1 kidney, so to speak. But some may need a kidney transplant and so on. So can you just say that, well, your organ is part of your body, and you put up advertisement that you have a kidney or you have this tissue or you have blood for sale. You are ready to give it to anyone who give you 100,000 Ghana cedis. Do you have ownership over your body? Do you have ownership over any part of your body? These are matters of what? Property law. These are matters of property law. And of course, when it comes to constitutional law and human rights law, we need not belabor the point. It's obvious. Issues which come up in this area of the law, certainly I've got constitutional implications and so on. And then the family law bit. Family law is also relevant. We'll be talking about treatment of children and also things like genetic decoding. Now, scientific knowledge with respect to health has developed up to the stage that as part, it's an extension of this assisted reproduction technologies. You can actually decode, right, someone's DNA, and you'll be able to tell the disease or health conditions which run through that particular line. So therefore, all those who are related or who descend, they can now be warned that if this person, for example, got cancer or got this and this and this and that, and if you are genetically related to that person, then you too, you are definitely in the line for those conditions. So when you get such advanced information, you are able to take the necessary precautionary steps so that you minimize your risk of actually becoming a victim of that, which has been established to be applicable to those who share a particular DNA and so on and so forth. So we see how medical law is actually broad in that respect. So from what I have said, what do you think is the function or the role or the importance of healthcare law? Yes. Ken? And this actually fits into the question I asked on the platform, that using maximum of 500 words, explain why you think law should intervene in medicine and healthcare delivery. I hope you did that. Are we communicating?
Look, yes, please. We are listening. But I think that it helps. The medical law helps to get to know actually each and every health professional's role, and even inclusive of the patients, allowing him or herself to be given all the necessary care regarding the requirement that you are placing as an offer to the health practitioner and how they are supposed to actually help you or assist you through your health process.
Okay. All right, thank you. Any other person? Because all of you did that work, so I want you to tell me what to put down under question 1. Why you think law should intervene in medicine and healthcare delivery? That's question 1, which I put on your platform. Don't want to talk, okay. Right, so the functions of healthcare law, medical law, include the following. 1, regulating medical or healthcare profession. And this is very important. And from my earlier explanation, you get to know that we cannot leave those who practice medicine, who practice healthcare, just on their own, unregulated, so that they can just do anything at all. No, that would be too much of a risk. So there's a need for regulation. Then it also governs the doctor-patient relationship. Just before I came here, I went to the dental clinic for a procedure, and I was just reflecting on my medical law while going through the procedure. So the relationship, what are the obligations of the doctor towards the patient? And to some extent, what are the obligations of the patient towards the doctor, as it were? Now, on this, I must emphasize that there is a unfortunate development in Ghana. When you mention medical law or healthcare law, people are just ready to pounce on healthcare professionals and think that everything they do is negative. Everything they do is bad. So sue them, sue them, sue them. That is just the thinking. But healthcare or medical law, I think, is much more than that. It is also to help healthcare professionals, to help the doctors to appreciate the need, right, for them to be aware of what the law permits, what the law does not permit, and even to encourage them to go beyond the legal boundaries. Because you notice, oftentimes, law may not set the bar too high. But if you're a good professional, you want to go even a step further than what the law is saying. So therefore, issues of ethics will come in. Yes, it's not that the law says this, and that is why I'm not doing it this way and so on. But as a professional who wants to satisfy his or her conscience that in accordance with the good practices of the profession, these things I am doing, are they right or are they wrong, and so on. So healthcare law will help to define some of these boundaries, or between the doctor and the patient, as it were. And again, I've also explained this already, that another function is that it helps to define the bioethical boundaries for medical advances and healthcare practice. So this subject will help us to know, in terms of innovation, right, in medicine, trying to break new grounds, things which could probably not be done previously, and so on. Should we just allow anything, or we should be careful? Not too long ago, I think it was in the news that, I don't know whether in the UK or one country, not too long ago, that they were able to use, I think, either sperm or egg contributed by, about 3 different people. So question is, if, for example, the sperm components were contributed by, let's say, 3 different men or boys, who is going to be like who is going to consider the father of the child, assuming that disclosure has been made, and so on, and the vice versa. So you notice that there are some things which can actually be done because the technology is there, but then we are not just machines. We are not just robots. We are human beings. We have cultures. We have values. So do you want anything goes, or we must actually draw a line? So this area of the law will help us to actually get that sense. Then it also ensures it also safeguards the public health and mental health. So public health, we talked about that not too long ago. And mental health is also important. And if you look at the definition of health by the World Health Organization, you notice that health is not just absence of physical, but also about well-being. And the well-being here will also include your psychological or mental well-being as well. Now, this area also ensures just an optimal allocation of scarce healthcare resources. We live in a finite world in terms of resources. We have limited funding for healthcare. Now, especially when it even comes to what we call the public funded healthcare, it becomes even more challenging, because if we put our money in the common basket and use it to finance health, but the money we put in the common basket obviously not enough to be able to meet demands by all patients and so on and so forth. So how do we determine? Let me give you an example. In Ghana, for example, when it comes to malaria treatment, okay, malaria treatment is not that expensive. So if you have maybe about 5,000 patients suffering from malaria, the cost of treating 5,000 patients suffering from malaria, let's say, is equal to one expensive maybe cancer treatment or some other form of treatment. So you ask the question, since we have limited scarce resources, are you going to ignore cancer patients who require more resources and rather focus on the malaria patients? Because I illustrated, let's say that the cost of treating one cancer patient can actually treat 5,000 malaria patients. Will you say that maybe let's follow the utilitarian principle, the greatest happiness for the greatest number of people? So if the 5,000 are certainly more than the one patient, so should we just go there and ignore this? So these are some of the things. And of course, we also come into the realm of what we call the cosmetic surgery as well. Things like Botox enhancement and things like that. Liposuction, trying to get like the flat stomach and so on and so forth. Should we say that those type of medical procedures are only for bodily enhancement or bodily modification? So we shouldn't allow scarce resources to be channeled through those areas and so on. Or when it comes to gender reassignment, that is, you do surgery to change your gender from being a male to a female, or female into a male, vice versa. the transgender people, or these are all medical procedures, will you say that because they are not really about making the person well or alive, is not an area where resources should be channeled? Again, healthcare law, medical law also governs the beginning and end of life issues. So, of course, beginning of life, we talk about assisted reproduction. We're also confronted with the issue of abortion, where people will say that, well, yes, I had unprotected sex, but I'm not ready to have a child. So the person will go and destroy a human life. So question which arises is this: should we allow people to just decide whether life which are started through their voluntary sexual act should actually be allowed to, fruition and blossom to become like a full-fledged human being? Or should we just say that once a human life has started, it's not for you to determine whether the person will stay or not stay? And you remember the famous case in the US, Roe and Wade, and the recent Supreme Court decision in the US, which sought to overturn Roe and Wade, implication it has for abortion. And I'm sure you've heard about the pro-life and the pro-choice debates, which is a very serious debate. And every now and again, they come up again in the US. So these are some of those matters. And again, end of life. People go through a lot of things before they die. Excruciating pain, misery, and all that. Should the law allow people who think that they don't have anything to hope for in life, they want to call it over, should they be allowed to take away their life? So we are talking about assisted dying. We're talking about euthanasia. Should they be allowed to take away their life? Or people should not be allowed to determine whether they live or they don't live? Especially so where people find themselves in what you call the medical futility. Medical futility simply means that regardless of the treatment, interventions, and all that, which the patient will go through, he or she is never going to come back and have a full functioning like a normal human being and have his life and so on. And typically, you've heard of the case of Anthony Bland against what do you call that, the airside NHS. No, there was a disaster in the Hillsborough Stadium and then around the Liverpool, and this gentleman got seriously injured, and he became what we call the PVS. That is, he was in a persistent vegetative state. That is to say that he was given food and drink by a system we call artificial hydration nutrition. That is to say that on his own, he cannot even eat food. He cannot drink. So unless you pass all these things through his or her system, like no, similar to the infusion, because he was more or less like on a life support. If you disengage the life support, is gone. But so long as you kept those systems in place, it remains alive. But beyond being alive, he doesn't have what you call the quality of life. Quality of life means that by the grace of God, you and I, we are not just alive. We can also exercise some of the usual functions of life. Currently, I am talking, you can hear me. I have my video on, you can see me, and so on. You can move about. You can do all manner of things, right? If you like football, you can go and play football. You like dancing, you can go and dance. You like drinking, you want to go to mosque, you want to go to church. You like sex, you can go and have it. You like just name it. Everything which goes into human life activities. Now that is part of what we call like the quality of life. But where you find yourself in such a way that apart from just having life in you, okay, you will not be able to exercise any of these life functions or activities. Then what it means is that you are alive, all right, but you do not have quality of life. So you are just existing. Now, in that situation, they call it the persistent vegetative state. Now, where you are in a persistent vegetative state, should you or people that you have given what we call advance directive. Advance directive simply means that you did a document saying that if I should find myself in a situation in which I cannot decide what should be done to my body or what should not be done, please make the decision on my behalf. Now, should the law allow a person in such a situation to actually end his life? So these are some of the matters. I'm sure you've heard of the dying clinic, what we call the Dignitas. Dignitas in Switzerland. They have like the clinic, and what they do, they just do palliative care and mainly helping people to die. So you go there, they prepare the necessary things which you need to take or apply to yourself, and then you die, and then you do it yourself, as it were. So people will even travel to Dignitas in Sweden, how do you call it, in Switzerland, to go and die, as it were, because in their country, it is offense to attempt to take away your life. Of course, in Ghana, we have recently amended our Criminal Offences Act so that attempted suicide is no longer an offense. But that is not to say that it is lawful for you to take away your life. So therefore, you can't go to hospital and tell the doctor that, doctor, I want you to end my life for me. No, that's a still criminal in Ghana. But of course, if you do it yourself and you are successful, nobody will come and arrest you and take you to court, because we'll just go and bury you, as it were. Now let's come back to the other work I gave you. I asked you to read excerpts of a lecture by Professor Sir Ian Kennedy in his famous BBC Reef Lectures, which was titled Unmaxing Medicine and subsequently published as The Unmaxing of Medicine. And then I gave excerpts to you. Are you able to read it? Are you able to read it?
Yeah. Yes, my lord.
Okay, so Mr. Aduma will tell us whatever you pick from that.
I looked at, there was this preposition which said that there might be a deviation from the normal state. And I also, in the reading, I also saw that women also have the capacity to bear children. And as whether in their old age or in their youthful age, they should have that capacity to do that. And also, one of the things I also saw from the reading was that should all illness be seen as something wrong, or should it be normal? So he tried to look at the word wrong, and at a point I saw that he was trying to say that when we say the word wrong, it simply implies of lack of moral worth. Lack of moral worth. So these are some of the things that I picked from the reading. One of the reading.
Okay, that is good. Right, thank you, Mr. Adumako. Any other person? Yes, let me hear other people. Can I hear other people apart from Mr. Adumako? Hey.
Yeah, Doc.
Yes.
Hello, Doc.
Yes.
Yeah, I also read his article on transmission, where he described modern medicine as a sort of dispensing case, in the sense that to him, he thinks the way modern medicine has been approached has been more than harm than good on the current generation. He also brought the idea of the doctor as an engineer who is involved in creative science procedure. He described the doctor as an engineer, and to him, the only thing the doctor is being seen as doing is curative medicine. But he professed the idea of really professing the preventive side of health rather than the curative aspects of health. So I think that's the few I also got it.
Right, thank you very much. What's your name?
I'm Ken, said.
All right.
Joshua Kenaka.
Okay, all right. Next person. Next person. Only 2 people read what I gave you. Only 2. I don't think you're really interested in this course, are you?
My lord, we are interested in it.
I'm teaching a similar one at University of Ghana. I have, I think, about 64 students. And I think about 45 are medical doctors, and then the rest are lawyers. Okay, so Ian Kennedy, in his work, actually addresses the issues of whether there's an imbalance of power between doctors and patients. And of course, those who bothered to read, you notice that of course, he has his own biases, if I may say. And then the other issue is there potential for exploitation of patients by doctors? And they also address the problem of, or the concept of illness. So in sum, or in brief, Ian Kennedy, in his Unmasking the Medicine, trying to say that the way society has approached medicine in terms of what really counts as part of medicine, society seems to have given more powers to medical doctors than they ought to have. Because in his view, there are certain matters which are not seriously medical. When he says medical, he's talking about not requiring technical, scientific, medical knowledge. That's what he means by that. And they are matters which can be resolved just by making social or economic or political decisions. And in his view, those matters which do not require technical knowledge should not be framed as medicine. Because as soon as you frame it as medicine, you give power to those who have been certified as doctors or healthcare professionals to decide those matters. And he had that particular problem with the concept of illness. That illness, I think I gave you one work by Derek Morgan. Did I give you that? Did I give you one author called Derek Morgan? The work I gave you, was there anything by Derek Morgan?
No, sir, there wasn't any work like that. He gave us Kennedy 1, Kennedy 2, and Kennedy 3.
Oh, okay. Right. So maybe I'll give that to you later. So there's that's the issue of like illness. So Kennedy will make the point that how we call something as being illness is in itself problematic. Now I'll give you an example. Now let's suppose, now as we are here, you're able to go about and know that everything is fine. Then just get a doctor to put a name, right, to a condition and put that as a tag on you. Immediately, your body will process, your brain will process that. And you who previously felt very healthy, fit, able, and able to go about, you will start becoming weak. Of course, there's a psychological aspect of medicine. And that is why, I'm sure you've heard of placebo before. Placebo,
Yes, Prof.
Good. So let's say that we have people who hold the view that for me, when I am sick, if I have malaria and then I'm not giving injection, the malaria will not go. We have some people who actually think like that. So for such people, if we even put ordinary water in the syringe, right, and you inject them, they will become better. But it was just ordinary water. There's no medicine in it. But because the person thinking is that, well, for me, I need to be injected. So that is how it also works with some of this concept of like the illness and so on. And of course, he also makes the point that there is asymmetry of information. That is, there's a huge information gap between patients and medical doctors or healthcare professionals. And because of that, patients are so vulnerable and they can easily be exploited by doctors, as it were. Yeah, so these are some of the points that he tries to advance. So if you look at the page 10 to 11 of his work, which I quoted, Carnegie argues that illness is in part a judgment made by those with power to make such judgments. And who are those with power to make the judgments? Doctors. So this is exactly how he put it in the book, quote, illness is a spurious scientific term, and the doctor, in purporting to determine its existence as an objective fact, is engaged in a series of moral, social, and political choices, which we permit him to make, unquote. So he's trying to make the point that it's not all the time that illness is purely objective. Of course, if you have malaria, that can be objectively determined because either you have the Anopheles mosquitoes parasites loaded in your bloodstream or not. So that can be established. But there are some others which, in his view, involve moral, social, and then political choices. Now, is medical ethics the same as morality? Now, in this area of the law too, we don't just concern ourselves with only what the law says, but we are also concerned about what the ethical position is. In fact, there are times that the law may have to fall on ethics. And when we say ethics here, medical ethics here, basically you're referring to the way and manner in which we are able to judge a particular action or particular course of action. I'm not talking about course of action as in the CA. I'm talking about course of action as in the CO. The course of action as in the CA refers to a factual situation when the law will give a remedy. I'm not talking about that. Yeah, I'm talking about course of action, that is a particular path or particular step you have to take. Now, medical ethics enable us to judge whether particular course of action, particular step, whether it is right or wrong. Whether it is right or wrong, good or bad, so to speak. But for example, we'll be talking about what has come to be known as principalism in medical ethics. Certain precepts have become so fundamental that if you are embarking upon any course or of action or any step, and you infringe those precepts, what you are doing will be viewed as highly unethical. For example, we have what we call like the principle of autonomy, okay? Autonomy is to the effect that the individual has his or her liberty. And for that matter, he or she is the master of what can be done to his body or cannot be done to his body. So he decides, he must give his consent and all that. Now, this is a principle or precept which has become well established that if you are doing anything in the field of medicine, and for example, you ignore it, your action will be judged as going against established medical ethics. Or similarly, we have the principle of non-maleficence. Non-maleficence, that is, avoid harm. Do not do any harm. And these ethical principles I'm talking about, they go back into the time of Hippocrates. Hippocrates, as you know, is said to be the father of Western medicine. Of course, he was a Greek philosopher and also a physician, as it were. And those days, those who wanted to learn the art of healing, because they didn't have medical school, you have to go and learn at the foot of Hippocrates. And Hippocrates will let you swear an oath. And you invoke all those days, we didn't have Christianity. You invoke the gods of the Greeks and all that. And you say certain things. And some of the things which are contained in the Hippocratic oath have actually become part of what we call the medical ethics today. And one of such is what we call the non-maleficence. That is, you have a duty not to do harm or duty to avoid harm. Do not harm the patient. So therefore, if you are doing anything in the field of medicine and we, for example, see that what you are doing does not have any benefit in terms of treating or curing the patient, then you are just inflicting pointless or aimless harm on that person. And that will be unethical and so on. Of course, we also have some approaches which have developed in trying to work out what the ethical position should be as far as certain matters are concerned. So, for example, we come across what we call the consequentialist approach, right? Consequentialist approach, which is also the same as what we call the utilitarianism. And by the consequentialist approach, we are looking like the consequence, that is the outcome of an act, in order to determine whether the act is ethical or not ethical, whether it is good or bad, whether it is right or wrong. So we don't judge the act itself, but we judge the outcome of the act. If the outcome of the act, for example, generates maximum pleasure or maximum happiness for greatest number of people, then because that act has generated maximum benefits, that act will be considered as right. It doesn't matter whether harm had to be committed to get that outcome. So that is what we call the consequentialism. We judge the rightness or otherwise of that action, not by the action itself, but by the effects, if you like, the outcome, the consequences. So therefore, in clinical setting, for example, we'll be told that consent is important. However, there's a procedure they call the laparoscopy, right? Laparoscopy is where the doctor is not very certain in terms of the diagnosis. And for that matter, he may want to do laparoscopy, which is some form of exploratory surgery, just trying to find out what is, just we are looking around in case we come across anything which is the problem. Then that gives you the basis for diagnosis. But as you start, you don't know, usually when you are going to open up a person, you have a target, whether you are going to this organ or this tissue or this, and so on and so forth. You don't just open up like a person. And then the person who is going to be opening up, he or she will have actually consented that this is what I am agreeing to be opening up for. But let's suppose that you were going to do something like the, what they call it, fibroid procedure, right? To remove a fibroid. And what the patient consented is the removal of the fibroid. But then, as you open up the patient, you also begin to see things like some other tumor, probably in the around, like something like the going to like the cervix and so on, so that if and that tumors too, your initial sighting of it means that it's not a benign tumor. We have what they call like the benign. The benign means that the tumor is there, but it is it's not cancerous. It is harmless. So let's suppose that what you saw was not a benign one, but it was active. But here is the case: the patient has given a certain consent, certain informed consent, that I'm going to be opening up for fibroid removal, and the patient has not been resuscitated yet because he's under anesthesia, full body anesthesia, or if you look anesthesia. Now, should you ignore the tumor and just focus on what the patient consented, knowing very well that if this tumor is also ignored, it's causing significant distraction that it may even end up killing the patient? So this is an ethical dilemma. Consequentialists will say that, yes, the patient has not given consent that you should go there. But then, if you go there and you remove it, you are going to have the greater benefit. It will save the patient from dying from cancer, and then the patient will live. So the outcome is greater. So don't be worried about the action. So this action here will be non-consented or unapproved action. But the outcome is to save the patient's life. So consequentially, to say that it's ethical, go ahead and do it. But we also have another approach, non-consequentialist approach, especially what they call deontology, D-E-O-N-T-U-L-O-G-Y, deontology. Now, the deontological approach to medical ethics is usually associated with Immanuel Kant's categorical imperative. And what do you mean by this? That is to say that for the deontological approach, they are not so much interested in just the outcome. They say that nobody is a means to an end, right? That the act itself has got a certain intrinsic worth, intrinsic value, which should be respected. So, for example, when it comes to, let's say, autonomy, right? A deontologist or deontological approach will say that respecting the autonomy of a patient is good in itself and is non-negotiable. And of course, autonomy here is linked to consent. So just like the example I gave you, the female patient just consented to removal of the fibroid, did not consent to the tumor. In any case, the tumor was not known. It was as a result of the fibroid operation, which actually also made the surgeon chance upon this active tumor. Now, the ontologist will say that so long as the patient has not consented, have not been given the information, and he or she have made up his or her mind that this is what I am signing up for, you don't have to go there. Just respect the autonomy of the patient. So here you see that for the consequentialists, the autonomy can be sacrificed because the outcome is far greater, going to save the patient's life. But the ontologists will say what? Will say no. Yeah, so as I will like you, yes.
So with what you are saying is more or less like having sorry, I'm citing our sisters and brothers who attend Jehovah with, like they will come to a facility and they will tell you that they are not taking blood infusion. So with them, if you think that there is a need for you to give them the blood so that they will survive, then giving it, you fall within the idea that yeah, it's good for the humanity. However, looking at the ontological aspect, they also say
Not
that
the
don't know
ontological, deontological,
the deontological, yeah.
Because ontology is a different thing.
Yeah, they also believe that yes, let's give them the autonomy. So even it will cause the death of that patient, they will not look at it. Is that not it?
Okay, now, okay, good. But Mr. Joshua Dumako, the difference with the example you are giving is that, you see, in the case of your example, the 1992 Constitution itself has got a solution to that problem. And the Constitution has a provision that no child shall be deprived medical care on grounds of religious what? Religious belief and so on. So if the patient is a child, then the Constitution says that you cannot say that the patient is a Jehovah's Witness or is this person, for that matter. You are not going to grant the blood transfusion, as it were. But assuming the Constitution is not there, assuming the Children's Act is not there, assuming Convention on the Rights of the Child is not there, then and we just have to work out the the ethical position. Then what you are saying will be really, really very helpful. Okay, so is there any relation?
Doc,
Yes.
Doc, please, I have a question. Usually, I know that in the healthcare practice, when a patient reports to the healthcare facility and gives a complaint, usually the first treatment that is given is malaria.
Okay.
Per our settings. I don't know if it's the same with other jurisdictions, but I know it's malaria, so that they will give you for a period to come for a review. With this practice, are we, if the treatment given per what probably the protocols of the clinical setting says, and then the patient reacts to the treatment, are we then going to look at it in respect of consequential, where the act is judged by the end results, not the means?
Oh, right.
Because
Okay.
the patient is reacted on that one, or we look at it that no other means, probably by just because this is the protocol, so I have gone through it, so I've cleared myself of the right protocols.
Oh, right. Okay. There's a particular problem we are dealing with. And I'm sure that your question is not a neutral question. You have a certain, you have something behind your mind, isn't it?
Doc, I think it's a general practice I have witnessed consistently. That's why I'm asking.
Okay. All right. Good. So usually, okay, we'll discuss what we call the medical negligence and medical malpractice as a topic on its own. So what happens is that, but let me add this. Early tomorrow morning, if I decide to do 1 hour class with you, do have the time? Otherwise,
around what time?
Otherwise, it will be in the probably in the evening. In the evening,
in the morning, around what time?
I think I have a certain meeting at 10, so I have to leave home by 9:30. So if I'm to do the class with you at exactly if I have my way, probably 7:45, will just be 1 hour. Otherwise,
Since it's a holiday,
tomorrow is a holiday.
I think you may prefer. Yes, please.
That will be fine.
Oh, really? Tomorrow is a holiday. Okay. Oh, okay. Yeah, but our meeting will still come on. It's at 10. So, or otherwise, it can be in the afternoon. Yes.
Please, it's Friday.
My Lord, I think tomorrow is holiday.
Not tomorrow.
Sorry, what did you say? Yeah, let's get one person at a time so that, yes, one person should talk so that it doesn't jam.
My Lord, I was saying that if tomorrow is holiday, then my colleagues, if there wouldn't be anything that will distract them so much, we can start from maybe 6.
Okay.
And maybe we end around 8, so that maybe we can have 2 hours.
Oh, okay.
If it will be okay with my colleagues.
No, you can discuss
in the morning or in the evening.
In the morning. In the morning.
Okay.
Yeah, if it's good for you, that is, since it's good for me, that is fine. So let's agree that tomorrow morning at 6 we have a class.
Yes, Prof.
Okay. All right, then let me answer the question I was answering, then I will draw the curtain down. Okay, I need to do some things for my stuff here. Good. Okay, so back to his question. You go to hospital and you follow the standard SPO, the standard treatment, standard operating protocol, the guidelines. You have followed it. And according to him, when it comes to most health facilities in Ghana, where somebody is brought, the first line of treatment is malaria. And then you did that and the patient got some adverse outcome. I think that's the question, isn't it?
Yes, Doc. They're probably drug bans or something. Yes.
Okay, so then get the drug bans or something. So in that case, within medical ethics, how will we judge what happened? If we are talking about, if you are talking purely medical ethics, we are not talking medical negligence. When it comes to medical negligence, the bar is different. So if you are talking in terms of, let's say consequentialism, and the thing about consequentialism is there has to be, you must have a resource. There should be something good out of it, not that you thought something good would have come. Because something good has come out, that is why you are using it to justify the rightness of what we did, which otherwise should be wrong. So in that case, for example, if the person got better, but here the person is getting bends. If the person has actually moved away from the symptoms of malaria, okay, so that the malaria is no longer present, except that you got some kind of like a side effect of this drug bans, so to speak. The consequentialists will say that malaria can easily kill, but this drug bans, for example, is not known to be killing victims easily. And for that matter, for the consequentialists, it is a right action to have embarked upon. But the ontologists will, as I say, will agree, because for them, they think that every act has got its own intrinsic value, and it should not be sacrificed for anything. Okay, so please, I want you to go back and the things that some of you have not actually made time to look at. Take advantage of between now and tomorrow morning, look at them, and God willing, tomorrow morning at 6, we'll meet here again. So have a good afternoon.
Thank you, Doc. Have a good afternoon.